Life Unrehearsed, brought to you by Lianas Senior Transition Support, helping you navigate home care and senior residences.
And good afternoon. Welcome to Life Unrehearsed. My name is Matt Delvecchio, specializing in life transitions, elder care planning, and the senior living industry. Coming up on the first half of today's show, have you ever heard of Law 18? Well, it's actually an important law to better protect people in vulnerable situations that went into effect on November 1st. And we're going to have Notary Anna Kamateros to tell us more about it and how it can benefit you and your loved ones. And on the second half of the show, is it time for a mixed healthcare system? Well, let's face it, our existing system is in shambles. So should we be increasing private sector assets to support the public sector, similar to systems in France and Sweden? Well, we're going to have the editor-in-chief of The Suburban, Bear Wiseman, on the show. He'll be in studio with me to debate this hot topic. Thank you for tuning in to Life Unrehearsed. It's a chilly one today, a little bit of sun. As our population ages, it's important to have essential conversations with your loved ones. Topics such as wills, powers of attorney, protection mandates are all extremely important, but it can be very confusing. And the laws have recently changed to better protect people in vulnerable situations, which could potentially make it even more confusing. So to help us navigate these issues, we have Notary Anna Kamateros on the line. Anna is the chair of the Wills, Estates and Planning Group at KRB Law Firm. Anna, welcome to Life Unrehearsed.
Hi, Matt. It's a pleasure to be here.
Well, thanks
for having me.
Yeah, no, most welcome, Anna. Thanks for joining us here. Let's start with wills, okay, Anna? So why is it important to have a will?
I mean, there's many different reasons, and they span from young to old in terms of age-wise. And just to sort of preface this, I looked, because I remember in 2015, there was a statistic, it was kind of staggering, that over 50% of Canadians did not have a will in place. And I just checked to see if there was anything more recent. And actually, very recently, the Royal Trust and Ipsos Reid, they actually they did a study, and I think it was based on the fact that, maybe the pandemic changed people's tendencies, and maybe people were getting their wills and estate planning, later life planning done. And it's still at the 50%, over 50% mark, with it varying from age groups. So the younger age groups, obviously, there's a higher percentage of people who don't have their wills in place. But it was actually kind of surprising to me, because at the beginning of the pandemic, I do remember I was receiving a lot of calls and a lot of people wanting to get their estate planning and later life planning done and in place. So that was just a little bit of a preface. But in terms of the importance of having a will, from the minute that you want to actually set out your wishes with regards to what's going to happen with your estate after you pass away, I mean, you would need a will. Otherwise, the law is going to presume for you. So our civil code presumes what a person would want to do in the normal circumstances. So we have different orders of heirs. We won't get into those details, but if you want to be able to control, if you want to be able to actually set out your wishes, and depending on your life circumstances, it's more important than others. So common law spouses specifically are not recognized under our Quebec Civil Code still. So if there is no will, a common law spouse is not entitled to inherit from her deceased or his deceased common law spouse's common law spouse. Furthermore, if you have minor children and they stand to inherit, it could be a big problem in the sense that up until 18 years old, they can't administer any property. Public curator would be overseeing the surviving parent's administration of property. The surviving parents would also be a co-owner, possibly, of, let's say, a family home with her minor or his minor children. So there's a lot of different scenarios there. Obviously, if you're older, or even if you're not older, actually, but if you want to leave a part of your estate to charitable organizations, a will is necessary, because the law is never going to provide for that either.
For sure.
So different scenarios. I mean, I'd like to keep it open for questions too, but that's a bit of a brief overview of the importance of having a will.
Sure. We're talking with Notary Anna Kamateros about some of the essential conversations we need to have with our loved ones, and I'm glad you expanded a little bit on why it's important to have wills in place. That number, I see it time and time again, Anna, like you, well over 50% of people still don't have wills. What's even more staggering is people think, okay, I've got a will in place, but it hasn't been updated, right? Yeah. They'll go years and years. How important is it to update your will?
So that's actually actually very important. So usually when I meet with clients, I usually say, you know what, take it out. If nothing's changed, like there hasn't been a huge life change, take it out every 5 years and make sure it still applies, or call your notary, call your legal advisor, call whomever you feel comfortable with discussing these things, who has a background in estate planning, let's say, and have a discussion as to whether or not there are some things that need to be changed. Otherwise, when there's a big life change, so let's say your children are no longer minors, they're over, let's say, 18 years old, and you're like, you know what, they wouldn't, if anything was to happen to me today, it wouldn't need to go into trust. I trust them. They could outright receive from my estate. I want to provide for them. Or if you have grandchildren and you want to leave a certain amount to grandchildren, there's certain things to foresee in a will, and that would need to be updated depending on the situation.
Right. So I want to move on from the wills, because another important legal document, several of them, and you see them day to day, Anna, I want to, in my world, as you know, I deal a lot with seniors and adult children, and I very often hear, I got a power of attorney, I'm good to go, no worries. And then, they're throwing a little curveball about something called a protection mandate, and it's always confusing. Can you sort of, at the 30,000-foot level, Anna, what's the difference between a power of attorney and protection mandate?
So I'm really glad you're asking that, because a lot of the time when people reach out about wills, then the corollary to that is to talk about what would happen in the event of incapacity. And then that's where we get into the discussions about powers of attorney, protection mandates. And like you said, there's a lot of misconceptions out there. I think a large part of it has to do also that Quebec is a civil law province, whereas the other provinces in Canada are common law. And in the other provinces, what we know here to be a protection mandate is actually considered an enduring power of attorney or a power of attorney in other provinces. So to go into, there's also, I often get calls about, I need to do my living will. And again, that's like a different story as well. So let's go through the different documents, and I'll give a brief overview, and then we'll take it from there. But a power of attorney, so a power of attorney, from the minute you sign it, you're authorizing whomever you've appointed as your power of attorney to act on your behalf, for you and on your behalf. So it can only apply to the administration of property. And I'm not against powers of attorney if they're done appropriately. So there are situations where they are useful. However, traditionally speaking, they have been so vast and not discussed and just signed without actually understanding the legalities behind them, that they've opened the door to exploitation. So a lot of people don't know that you can limit it in time. You can limit the amount of the things that your power of attorney can do. You could put a verifier clause in there so that there's some kind of oversight. It's creative, and that's where it becomes important that you speak with the right legal professional.
And from what I understand, a POA, power of attorney, is really a temporary document, but it could help when you have to do finances, say, for mom or dad or grandparent, right?
Absolutely.
And now if we move into the protection mandate, and this is where a lot of people get confused, why do you need a protection mandate if you already have a power of attorney?
So a protection mandate, contrary to the power of attorney, a protection mandate comes into effect only when we get a judgment declaring the person who gave the mandate no longer able to make decisions with regards to his or her property and or medical decisions. So in the protection mandate, we're naming the person who's going to represent us, and it could be one person, it could be several persons, you could divide the tasks, but we're naming the person or persons who will represent us in the event of incapacity. And technically speaking, if that mandate, that protection mandate, is fancy term, homologated, just to say that a judge needs to stamp a judgment so that it can come into effect, and we hope to never use it, but it is there in the event of. Sorry, I lost my train of thought.
No, but you need, just because you have a protection mandate in writing, you actually need to go through this fancy term homologation process so that it gets executed, I guess, correct?
Exactly. And traditionally speaking, a lot of people would choose to do a power of attorney and a protection mandate because in order to get this judgment to enact the protection mandate, there's usually around a period of 6 months to a year that can go by. You have to get social workers' reports, medical reports, and then a proceeding needs to be done, which can be done entirely by a notary or can be done in front of the court. If it gets contested, that's a whole other story.
Right.
But basically, during that gray zone period, our civil code provides so that a power of attorney can continue to produce effects during that time it takes to get a judgment, because we're in that gray zone period. A power of attorney no longer applies when someone is no longer deemed able to make decisions. That being said, we need that judgment to actually declare a person incapable of making decisions. So during that gray zone period, the power of attorney can produce effect. And that was traditionally one of the reasons why a power of attorney would be done at the same time as a protection mandate.
You're listening to Life Unrehearsed. Matt Del Vecchio. That's the voice of Anna Kamateros. She's a notary that's helping us explain the differences between some of these technical terms. Now, Anna, you are very much involved and educating the public about this new Bill 18 that came into effect on November 1st this past year. And really what it's about is protecting vulnerable people. So we want to hear a lot more about that. But first, we have to head out to the CJD Traffic Center and let's hear from Jill Fitzgerald. Welcome back to Life Unrehearsed. I am Matt Del Vecchio, and I'm talking with Notary Anna Kamateros about some of the essential conversations we need to have with our loved ones as we age. And now, Anna, I'd like to talk about this new Bill 18 that came into effect on November 1st. Can you give us a little breakdown of this bill?
Yeah, sure. So there were a lot of things that were introduced with this bill, but just on a high level, I'd like to focus on three different aspects. So the main purpose of this bill was to preserve autonomy and also preserve residual capacities of older adults who are in vulnerable situations presenting cognitive decline and so on and so forth. So the idea here is to veer away from the traditional ageist belief that, you know, if you're an older adult and in loss of autonomy or in cognitive decline, you're totally incapable of making any decisions, and we need someone to start making decisions for you and on your behalf without even consulting you. So we're veering completely away from that. And someone who was actually really instrumental is a colleague of mine who I actually present with a lot, Anne Soden. She was really a huge advocate on this and helped, in my mind, she helped evolve the law a lot in this aspect. So one major change actually is that we've abolished the regime of curatorship, which basically was the situation where someone would be deemed totally and permanently incapable of making any decisions. That type of representation no longer exists. And when I talk about curatorships or tutorships representation, it's what comes into effect when someone is no longer deemed able to make decisions on their own and does not have a protection mandate in place. So just to give that nuance. And now what we have is only tutorships, and they're considered modulated tutorships. So that means that we're no longer declaring people totally and permanently incapable. The abolishment of curatorships is actually very significant because someone under tutorship can do a will. The will have to be confirmed by judgment after the person passes away, but they could do a will if they have the capacity to do so, and there's ways of doing that. They can get married, they can vote. In the evaluations, we can determine whether or not they have the capacity to administer a certain amount of money on their own, work and administer their work products. So, you know, the idea is to promote capacity more than declaring anyone incapable of making decisions for themselves and on their behalf.
You know, in talking to a lot of people in the community, and I think that is it, promoting capacity as opposed to incapacity. It's a big change and a shift in ideology and perspective. And so it is being welcomed by the general population. So getting into a couple more details, Anna, one of the things in Bill 18 is something called temporary representation, which is new and actually very good, isn't it?
It is. It's very good because you no longer, let's say someone is, it's the ideal scenario for someone who is let's say someone is in a coma, but we don't know whether or not it's a permanent situation if they come out of it with their full capacities and so on and so forth. And their house needs to be sold because there was a promise to purchase and the house needs to be sold. Well, that person is not able at that moment in time to go and sign that deed of sale. A temporary representation is a solution there that could be brought forth.
So, Anna, just on that note, okay, I think this is such an important point. I see that a lot. My wife is a real estate broker, and she's had some families that have just been devastated because someone is declared inapt and they can no longer sell that property. Mm-hmm. And then they had to go through what you were talking about prior to the traffic break, is something called homologation. Now, if I understand correctly, there is that possibility to sell a property through temporary representation?
Well, if someone has a protection mandate that we're homologating, if they have a power of attorney that authorizes the sale of a house, during that time, that we're waiting for the judgment, the house could technically be sold. So there's that fiction in the civil code, but also the temporary representation. I don't know if it would be the ideal in that scenario. I would think more basically a specific authorization to sell would probably be quicker and more efficient at that point if we're already in line to homologate a mandate, let's say.
Got it. Listening to Life Unrehearsed, Matt Del Vecchio, and that's the voice of Notary Anna Kamateros. We're talking about some essential conversations, and specifically Bill 18, which was just passed and became into effect November 1st. Another term that's relatively new for a lot of us, Anna, is something called assistance shift. What does that mean?
So assistantship is a new measure, completely new, and it's actually very interesting. I'm actually very interested to see how it's going to evolve. So contrary to the tutorship that we just discussed and homologating a mandate, which has to go through the court eventually for a judgment, this is done entirely with the public curator. So it's more of an administrative procedure, and it's been created for people who are living through a difficult situation. So this could be broadly interpreted. We're not talking about a person who's in serious cognitive decline and has incapacity issues. We're talking about someone who could present some cognitive decline but still has capacity to do everything on their own. So assistantship is there so that that person can appoint an assistant, someone who's, let's say, like a trusted family member or friend or so on and so forth, to be appointed so that they can represent them in different scenarios, but without actually having any signing authority, without having the right to actually do any transactions in their bank accounts and so on and so forth. So they would be able to retrieve information, but they wouldn't be able to act on behalf of the person who has appointed them as assistant, which is actually a big thing. So I'm curious to see how this is going to evolve. There is a criminal check that's done as part of the proceeding to make sure that the person who's going to be the assistant doesn't have a criminal background. There is a procedure to follow, but it's a lot more streamlined and done essentially with the public curator. There's a register that's going to be held also by the public curator that is going to inform people whether or not they are dealing with an assistant or not. So it's very new.
Very new. Very interesting to see how this will play out, like you say. One real quick one here is something called a verifier clause. Quite important when with a protection mandate that now requires a verifier clause. What does that mean?
So traditionally, before this law came into effect, there was no requirement of oversight with a protection mandate. So unless there was a verifier clause in the protection mandate, basically when it would be put into effect, when it would be homologated, the person appointed, had carte blanche to represent the person that the mandator, the person who gave them the protection mandate, without any oversight. And that led to situations of exploitation, and also by having a verifier clause there, so by appointing a third party to whom the mandatory will need to render account to on a yearly basis or shorter, we're actually protecting the mandatory as well. So they're going to have a track of how they administered the property and what kind of decisions were made. And by having that oversight there, they can also be guided, because a lot of exploitation a lot of times is done by miseducation, not being informed of what their duties are, and this idea that we have powers over. So that's a big change too that I welcome. We were always doing verifier clauses, to be completely honest, even before. But this change is really welcome.
Very welcome, and the spirit of Bill 18, right, to protect those that are more vulnerable, and they're going to have a bit more power there. Anna, you've been very helpful. I want to thank you very much for joining us here on a Saturday. How can our listeners get a hold of you if they need more information?
So they can go to the KRB website, krblaw.ca, and find me there. Otherwise, I don't know if you have a page, Matt, I could send you all my information and you can post it if you want.
Absolutely, Anna. I'll gladly post it on our Life Unrehearsed Facebook page. I want to thank you very much again, Anna.
Thank you. It was a pleasure, and have a great Saturday. Happy holidays to everyone.
You too. That's Notary Anna Kamateros. Anna is the chair of the Wills, Estates, and Planning Group at KRB Law Firm, and you could reach out to krb.ca. And next up on Life Unrehearsed,
make your computer.
Is it time for a mixed healthcare system? Maybe we should be increasing private sector assets to support the public sector, similar to systems in France and Sweden. Well, we're going to have the editor-in-chief of The Suburban, Beryl Wiseman, in studio with me to debate this hot topic. He's already in studio. He's fired up. And we're also going to be taking some calls and texts to hear your perspective. That's on the second half.